Waryat. Dr. Anil G. Waryat is holding the charge of Registrar of Maharashtra National Law University, Mumbai. He also serves as the Director of the Center for Research in Criminal Justice and the Chair Professor and Director of Justice M.L. Painse Chair in Environmental Laws. Before joining Maharashtra National Law University in 2019, he served as the Professor Head of the institution and Deputy Director at Amity University Law School, Mumbai. He also served as the Professor Officer on Special Duty and Head of the Department of PG Studies at Maharashtra National Law University and Faculty in Charge and Coordinator of SNDT Women's University's Law School. He has appeared before the Parliamentary Standing Committee on the Clinical Establishments Bill 2007. With over 2 decades in legal profession, he teaches constitutional law, corporate governance, international humanitarian law, comparative public law, and environmental law. He has authored 4 books and more than 30 articles. 3 PhDs have been awarded under his supervision. I would request Varadi ma'am to felicitate Anil sir.
कोई दूसरे नहीं है
Thank you, ma'am. I would also like to call Mr. Harry upon the dais.
Thank you. This session is on judicial review of administrative actions. It's not, judicial review is not a big subject, it's quite simple and straightforward. There's a lot of law associated with it, but the subject is relatively simple. And I'm sure that the speakers this morning will show you how simple it is. So without further ado, could I ask Mark Roberts to come up to the lectern?
There are some very significant hurdles for me to face in presenting this, mainly that the presentation we did on yesterday of cross-examination was something that I think a lot of us enjoyed and had fun doing, so I've decided to present today's discussion in a very different way. As distinct from me standing up here and just lecturing you for the next half an hour, which is not going to be very interesting, I've decided that we're going to make this a Socratic debate between us here today and involve the students, to force the students to answer a question. When one looks at judicial review within the legal frameworks of Australia and India, at face value it appears to be very similar, to involve the same sort of considerations. Harry and I, in preparing this paper, have ultimately formed the view that despite those initial appearances, judicial review within Australia and India are in fact significantly different. I want to read to you a quote from a learned Indian author which I found last night, which is going to essentially frame the question that I'm going to ask the students to answer. The learned author said as follows: beyond doubt, judicial review exercised by the Supreme Court and the High Courts has played a crucial role in ensuring constitutional government in India by keeping the Union and state governments within their respective jurisdictional spheres. However, the concept of judicial review has been subjected to serious criticism. It's been closely associated with judicial activism. It tends to elevate the judiciary to the rank of super legislature. The approach of the courts has opened the floodgates to litigation and given rise to significant friction among the various organs of government. The other thing that I found over the last few days, in fact I read in today's paper, was that the Supreme Court today is commencing what I think will become a landmark decision handed down in relation to same-sex marriage. The petitioners have sought to invoke, no, let's say that slightly differently, have sought to strike down the 1954 Marriage Act as being invalid. As I understand what has occurred, a bench of 5 has been specially constituted to hear the arguments of the petitioners and the various interested parties in relation to whether same-sex marriage should be permitted within India. As I further read the papers and articles which have circulated over the last day or two, it appears one might get the view that the Supreme Court is building upon its jurisprudence from a case which I think I will hopefully pronounce correctly, but excuse me if I don't, Navchat Doha, which was a case involving where the Supreme Court decriminalised sexual activity between consenting adults in private and same-sex relationships. And there is a belief that the current petitions before the Supreme Court, just as it starts today, will be asking the Supreme Court to take that further step in order to determine that consenting adults of same sex can marry. What I found to be very interesting and relevant to the topic that Harry and I are talking about today is what has been said by the respondents in opposition to the petition. Most striking, I suppose, was the view that the relief being sought would entail the judicial creation of a new institution. One of the respondents to the petition has said that the view of the petitioners represents merely urban elitist views, which cannot be compared with the appropriate legislature that represents the views and practices of all India, as opposed to simply the few. And so we have a situation in many respects where the Supreme Court of India is going to be asked to do something which Harry and I don't believe occurs within Australia, and that is to explore difficult moral questions in relation to the validity of the law. In Australia, those difficult moral questions are left to the legislature. But on my understanding, speaking with many of you, including in my interesting discussion this morning, the reason it appears that the Supreme Court of India is able to explore these more difficult concepts is because of the way the Constitution, which would be called in Australia progressive interpretation of your Constitution, also is known here as the Living Constitution or the Living Constitutional Tree, invokes the ability for the Supreme Court to view your Constitution in regard to current day ideas as to morality, as to economics, as to social interactions. In Australia, by contrast, we don't have, generally speaking, or it's not generally accepted by our High Court, that we have a living Constitution. Some of our previous High Court justices, such as Justice Kirby, went as far as any of the High Court justices have ever gone in order to invoke this notion of a living Constitution, but by and large, that is not what occurs within Australia. Later today, Mr. Hayes will be taking us through a very interesting hypothetical involving environmental issues. The other thing that I noticed in looking and seeing what had happened in India over the last 30 years is the developments that have occurred within the Supreme and High Courts concerning environmental law within India. And what's been described in India as the most progressive changes in any area of law that India has seen since its development in the 1950s. A question which I'm going to pose to the students, in which I invite the students to speak on is whether you agree or disagree with the criticism of the learned author I quoted before, that the role of the Supreme Court in India has effectively gone too far in becoming an interventionist body or a third arm of government. What do you think?
इतरांना वाटायला होईल.
Come on, this is where you guys, you have to do some work now. This is where you guys are going to tell us what you think of that concept. Or perhaps if we can have one of the teachers kick off the discussion.
Right from the time when our constitution was came to be, the understanding was that it will be a great constitution. It will be a constitution that will evolve itself, with changing times and changing circumstances. One mode of doing that is the legislative mode. Our constitution had an amendment procedure, and amendment was supposed to be carried out by the legislature. But then there was a provision in the Constitution, Article 141, the law declared by the Supreme Court shall be binding on all members. Now, what that led to was that whenever the Supreme Court pronounced about something that became a part of the law to be applied for the future. Now, how should that made the Supreme Court the final article? So what is being discussed, what's being talked about is that should the Supreme Court hold this power beyond the power and laying down the laws for us, rather than the legislature, which has the duty to do so, doing it. So should the Supreme Court do it, or should, that is one part, and two, is there a reason why the Supreme Court should not do it? Does it in any way hurt our long-term interests in the sense that the ideal separation of powers would come under challenge in such circumstances? So let's speak a bit about it. Let's participate in this.
So the question was whether the Supreme Court should, make laws. What I feel is that in India there is no strict separation of powers. In some way, because we are a huge country, some of the powers which are given to the legislation are also done by the judiciary. For example, when there was this case of Husainara Khatun, that was like one of the first cases of public interest litigation in which Advocate Hindu Rani, she, in that case, there was these prisoners, Husainara Khatun and few of the prisoners, and they were not able to stand in the court of law to ask for justice. So the concept of local standing was done away with, and hence Advocate Hindu Rani represented the prisoners. So that was public interest litigation, and in that case, so what I'm trying to say is that yes, in certain cases, the Supreme Court should have the power to look into whether the legislature, the laws made by the legislature and the executive and the administrative actions, are they ultra vires or are they outside the jurisdiction, outside their jurisdiction, and also are they in violation of the fundamental rights of the public. If the legislation, of course, which is elected representation of the people of India, in many cases what happens is the legislation does make some acts or laws which are in violation of the fundamental rights of the human being. Hence, the Indian citizen goes to the court of law at the door of Supreme Court asking for justice that this law is violating our fundamental rights. And I think in that power and I think in that scenario and in that perspective, Supreme Court does hold
precedents, which is also called as chair decisions, like whatever Supreme Court is announcing as a law is followed by High Court and the law, like the whole country. So it depends on case to case and in certain situations.
Yeah, I suppose one of the responses that I would have for you is that India, like Australia, has decided to elect a body of people to be the legislature to make laws on behalf of all Indians. Are you comfortable with the Supreme Court being given the responsibility, separate to Parliament, separate to the will of the people, to create law?
Actually, Supreme Court is the custodian of Indian Constitution. So if whatever is out, if the people of India feel that the legislature, the laws made in the Parliament by the elected representative is in violation of the fundamental rights of the people, then I think they have the right to have justice. They can seek justice at the court of Supreme Court. Now the Supreme Court will decide is whether the laws made by the legislature, because they are also the elected representatives. And in that sense, I am saying that India does not have strict separation of powers. Like maybe I think in Australia there might be strict separation of powers. The executive is executing, the legislature is legislating, and the judiciary is adjudicating. That's it. And also I read your paper in that when there is a concept of judicial review in Australia, so the High Court can only talk about the legalized, like whether the law is legal or not, but it cannot change the law. The law has to be made by the legislature in Australia. And I think
Thank you. Come on.
So according to my view, the Supreme Court being the interpreter of our Constitution of India, what we have seen in India is not diversified. And whenever we saw the Parliament it might be in full majority with either one party who is biased against anyone. Let's have an example of any party who is being biased of anyone. And if you make some laws for them, which is not being like, it might violate the fundamental rights of others. So here the Supreme Court, judicial activism, which we have read about, that judicial activism, like we can take the example of Vishaka's case. At that time, we don't have any law for the harassment, sexual harassment of women at workplace. But that law was for like 20 years now. Whatever the interpretation given by our Supreme Court, given the basic structure document, which is the case of Keswan Gandhi versus State of Kerala, in 1973, the Supreme Court gave its judgment that the basic structure document, which cannot be amended. It was a very good because whatever the base of our constitution, our laws, we are being amended and it might be misused by the parliament and whatever we are saying. If some power is given, like arbitrary power is given to anyone, they can use it in a wrong way. So the arbitrary use of power in a democracy is a prohibition. And that check and balance is maintained by Supreme Court, our judges, the interpreter of the constitution, the judicial activism or whatever. They can take the PIS also anyone. We have seen in 1918 that Justice P.M. Bhavati and Krishna Iyer were the founding fathers of public interest litigation in the case of Sanara Khatmi's State of India. So these all were the concepts where Supreme Court took step ahead and safeguarded our constitution everywhere through its activism. So I think that Supreme Court should make the laws and the permissible overlap, whatever is allowed, in the separation of powers and checks and balances of our constitution is very well maintained. Each and everywhere, like the check on executive by the legislature and judiciary, the check on that legislature by the judiciary that any law should not violate their fundamental rights, which is provided under Article 13 of our constitution. So it's quite good. Supreme Court should be.
Does anyone disagree that the Supreme Court should have that level of power?
Yes. In Supreme Court, under the judicial activism, whenever they pass any law, we have seen they are correlating with different cases and different legal problems. For example, our Indian Supreme Court has appointed a committee to pass the data privacy law. When they were working on data privacy law, they have enacted or passed 3 more acts which were bigamy marriage, LGBT marriage. It has made the gay marriage or the LGBT marriage they have made legal in India. We have different laws of the bigamy. So while working on a problem statement or working on one legal problem of data privacy law, how the personal privacy of a person can be looked at. So judicial activism is the only process where the judges can interconnect between different problems. So judicial activism is certainly necessary. So this is what my view is. Because when law otherwise goes to parliament to be enacted, that law goes in the silo, in discrete nature. They don't interdiscipline the problem statement. But where judge can correlate, they can take reference of the previous case law, of the previous cases, and during giving judgment of one case, they put up some kind of judgment which can be enacted into the law. So judicial activism is like the key. And if you see, especially in India, the people who are competent enough, intellectual enough, those are more, rather than elected members, the judiciary are our, it's called as fourth pillar of our democracy. They are come the more wisdom, more intellectual, and they have some scientific measures to enact that particular period or enact that particular law. So judicial activism is certainly necessary. That is necessary.
I have a very different approach to your question. What I generally feel is, in India's political context, the duties and powers of all the three bodies, the legislature, the executive, and the judiciary, have been clearly divided. And when it comes to the situation, as the elected members will be capable of drafting a particular law or not, It's not the elected members per se. We have drafting committees, we have bureaucrats who have knowledge of a particular field and they sit together and draft the law. It's the elected members who discuss the law in the parliament. Now when it comes to the judiciary, it's not that the judiciary does not have the power to enact a particular law in the country. It is done by a precedent in India. And we can take the simplest of cases. Like for example, the law of laws is unqualified in nature. But the rule of absolute priority still applies in India because of the landmark judgment which says that so and so should be applied. And it is applied as a law in the same context. Now, the power of judicial review is extremely high in India, and the best example of this is the National Judicial Appointment Commission, the bill of 2014. Here, the Parliament or the executive is trying to take over the powers of the judicial system. So, the judiciary struck down the bill and called it other the powers given under the separation of powers. So, the Supreme Court should act as a watchdog, which it already does. Has the power under the Constitution to not enact the law per se, but own a precedent which will be applied as a law. So, not in the clear written meaning or written sense, but the Supreme Court does have the power to establish the law.
I think I'll start just easier. I think what I'm trying to say is we're trying to provide a fresh perspective on the Supreme Court in India, or general, and the doctrine of the Constitution. And we just want to say, I guess, provide a fresh perspective on the challenges that are being posed. Because at times they say justice, it's like justice according to who? According to the business groups or according to the environmentalists. When they are competing interests and morally contested questions, justice can lie in very different forms. But I think the doctrine of the Constitution is great because it represents the highest ideals of our society, where we stand, what we're trying to achieve as a society. But I think there are challenges to that structural system where you allow morally contested questions to be contested in the court of law. And I think that's what Martin and I are trying to point out in this conversation, that to see your perspective as when challenges such as justice according to who, or where the public interest lies, is it a wealth money, is it number games, you know, I think that there's a development project and there's a petition filed to stop that development project. Is it the businessman, what constitutes the public interest in that sense? The businessman or the villagers or the environmentalists, or who is the public interest? And that's where I see like, oh, there could be a challenge in that situation to decide where the public interest lies and where we are in justice, like local security. But that's like what we see from an outside perspective. Of course, in practical sense, you guys are way more aware of how it works and the implication that it might take, and maybe the challenges it poses as well. But yeah, that's our 2 cents and perspectives. And I think Dr. Wood might have some perspective on that too.
Would you like to comment on what you heard? You can do that. From here. Or you can go to the idea. Mr. Chair. Department of Economic University, and participants here. I'm Dr. People. First of all, I thank the Department of Law and its faculty department for inviting me over here. And the session is on judicial review, utility, and taking the administrative decisions. So I'm not having much insight into the judicial review as is followed in Australia. But what I understand is that there are certain things common to India as well as Australia. That is, firstly, all our judicial and administrative institutions are in model in line with the English system because of historical reasons. Our legal process and thought process are in model along with the line of English system. Judicial review basically an American concept which we have adopted in policies from both the countries for a reason. And I used to wonder always how effectively we could fit legal judicial review into a parliamentary democracy. Of course, while adopting the parliamentary democracy, India had been very conscious not to recognize the parliamentary sovereignty as that was there in the Britain. To my understanding, the same with Australia also. As far as India is concerned, administrative actions are being subject to public scrutiny even before the commencement of the constitution. And both the system, both judicial system, owe a lot to the prerogative which is now known as the constitutional risk in both jurisdictions. But what I have learned from the discussion over here and my limited readings that the judicial review has brought an impetus in Australia almost in the late 70s, maybe because of the establishment of the federal court in Australia and also the administrative appellate tribunal, if I am not wrong. And the second aspect may be the contribution of the High Court. It has used the writ jurisdiction to safeguard the individual rights against the arbitrary actions of the administrative legislative process. See, I would draw a parallel between these two systems, especially with the time point of view. I also guarantee that I will not stand much between the universal and Netherlands and will take only few minutes. See, though India, can we say American concept of judicial review? In the American Constitution, there was no express provision of judicial review. Whereas in India, under Article 40, we have made specific provision for judicial review. But we may recall the words of Chief Justice Marshall, who said that any nation which has framed a written constitution has intended it to be the supreme law of the land. I have my own views with respect to India. I have my own reservations whether framers of the Indian Constitution really intended to bring in a constitutional supremacy in India or not. And this 1970s, the later part of 1970s, is very much important for Australia as well as India because we have certain remarkable judicial pronouncements in this point of time. Starting with the celebrated Keshavanta Bharati versus State of Kerala, wherein the Supreme Court has introduced a doctrine of basic structure and said that though the Parliament, in a parliamentary system, Parliament is free to amend all or any provisions of the Constitution, that amendment must be done without destroying the basic structure of the Constitution. The doctrine of basic structure, though it was argued Previously, 10 years before, in another case, a case of Goenka case and rejected by Supreme Court, it was reinforced and recognized in Keshmanandapani case. In fact, the Indian Supreme Court was introducing a concept which was never in the agenda of the Constituent Assembly. So again, what I thought when I came across with the decision of the Keshmanandapani case when I was a student of BA Political Science. Viewing from the political science point of view, I always thought whether the Supreme Court is competent to bring in a new doctrine which was not in the intention of the framers of the Constitution. But again, the case in R.C. Cooper versus Union of India, Madhav of India's case, and also the tradition, expansion of scope of judicial review by inventing a new dimension of equality. So earlier, the criteria on which the judicial, the pre-17 era in India, the criteria in which the Supreme Court could, the judiciary could invoke the provisions of judicial review was to test the reasonableness in the light of the express provisions of the Constitution, Part 3 of the Constitution. But the provisions have been so widely interpreted, especially with respect to Article 14, that equality, where the conventional system of reasonableness of classification and the rational access between the objects already achieved and the, and the law, legislation, has been given a go, and concept like fairness, ultra rights, because in Australia also there is a concept of judicial error, where the courts are able to reach widely to the cause of the people. Judicial error, jurisdictional error, I say jurisdictional error, because more and more administrative decisions are scrutinized according to jurisdictional error. A parliament can be drawn in Indian system with ultra rights, where the administrative authorities cross their limits, exceed their authority. Then the concept of ultra rights is taken by the court to scrutinize them. Similarly, procedural fairness as you have in Australia, we also have the fairness of procedure. There impropriety of decision making, and the entire ambit of natural justice that has been recognized by the judiciary in India to advance the cause of judiciary. And especially after the liberalization, where the activities of state is shrinking and the state is withdrawing from major activities, there is a wider practically fundamental rights of the people. And more powers are given to administrative agencies where they use a lot of discretion. Discretion basically has no criteria. But in the process of decision making, the rights of the citizens can be hampered. So these expanded concept of safeguards, procedural safeguards, including procedural safeguards, have been used to protect the rights of the citizens. Right from Malanandi case and EPOA case, a new path must be opened by the judiciary in India with respect to judicial review. And the state action, the administrative action, executive action, has been made more and more open for public scrutiny. So this is what I want to share with respect to the Indian position and trying to bring a comparison to the Australian position. So with this, I try to back up my views. Thank you very much once again for taking the opportunity.
Thank you, John. Okay, we go to lunch at 1 o'clock. It's 10 to 1 now. Do you have any questions? I'll give you the opportunity to ask short questions. Put your hand up.
Good afternoon again. So in this paper, like on page 15, it is written that what can India learn from Australia? Page 15. So, yeah, the question is, in this line, while India's judicial review framework has produced positive results in protecting fundamental rights and improving access to justice through public interest litigation, it has often been criticized for undermining democracy and the separation of powers. So the separation of powers, I can understand because we do not follow strict separation of powers. But I want to understand your perspective, like how judicial review in India is undermining democracy.
Can't hear you up there, so I would just.
I have to hold it very close. Okay, let's have a go. The question that you asked is particularly pertinent today in Australia because we are in the course of, we are presently going through a process to amend our constitution. The purpose of amending that constitution is to give our First Nations people recognition in the constitution. And we're going to have a referendum which we need to amend the constitution. Now, one of the issues which is currently being debated is how do we insert a provision in the constitution to give First Nations a voice, and that's the term used, a voice. The government has said we will give them the right in the constitution to advise the Parliament and the executive on any legislation that affects First Nations people. Now the issue there is, and this is where it brings in the possibility of the Supreme Court or the High Court in Australia having a say in how that is to be interpreted. For example, if there is a voice which is to be made to the Parliament and the Executive advising on what laws should be passed which affect First Nations people, and if it is left at that, and that's all the proposed amendment is to the Constitution at the moment. The big issue will the High Court have the right to determine any challenge to a failure of the Parliament to have regard to the advice from the First Nations people? And that would be done by judicial review on the grounds that they have not adequately, for example, consulted with First Nations, or they have not adequately considered the views of First Nations, etc. And that's a really critical issue that we face. Now, in India, the Supreme Court, which is the equivalent of the High Court, has gone down that path and adjudicated upon the meaning and the application of the Constitution. In Australia, the High Court has limited itself to strictly whether or not the action complained of is in accordance with the Constitution or is in breach. In other words, whether it's ultra vires the Constitution. So we have this first time, in my view, we are going to get some kind of relationship between the way in which India has construed its constitution, if the amendment in Australia goes through, where First Nations are able to advise not only the Parliament, but the executive.
I do or we put this whole vocal application government as a mandate of the people. And what is to be decided, what laws to be made, and what policies to be formulated, it is basically the prerogative of the executive system. And the judges who are not responsible to the people, neither having money of the people, they come and sometimes they hamper the personal democracy to examine. Take the case of Chairman Goyal versus State of Congress. The government was trying to implement the reservation policy as part of the social commitment. Now, Supreme Court struck down the reservation policy as a whole. Take the case of bank nationalization. To implement the socialistic ideals, banks were nationalized. The court was struck down nationalization. And take the Indira Swamy versus the case, which was like OBC reservation, which was diluted with the introduction of creamy persons. So there have been so many instances where democratic aspirations have been diluted or blocked by judicial review. And many a time the government has to resort to constitutional amendments to get rid of the difficulties created after judicial decisions. We have been a lot of instances of this one cannot try.
Okay, it's time for lunch. Can I just thank our speakers and ask you to join with me in thanking them, and we'll come back at 2 o'clock after lunch.